Hello, everybody. My name is Philip Palumbo. I'm the host of the Palumbo Pulse, where I interview some of the top market strategists, economists, and advanced planning specialists to help maximize your wealth. Today, I have with me Neil Katz, who is an estate planning leading attorney on Long Island, an adjunct professor, and has been in his field, studying his field, and doing a great job in his field for greater than 30 years. So, Neil, thank you for coming on the show.
Thank you, Phil. Thank you for inviting me to spend a little time talking about a topic I love to talk about.
All right, terrific. So I'm obviously a wealth manager, Neil, right? You take care of the estate planning part. When I talk to clients all the time, I always, once I get past the investments, the portfolio, and the financial planning and what we're going to be doing strategy-wise together, the next question I ask clients is, if you suddenly died tomorrow, or your husband, or both of you, if they're married, what happens to your money? Who's going to inherit your money? So could you share with our audience why it's important to have a plan in place for these types of events?
Well, that's a good way for you to start, and certainly a great service for you to provide to all the people that you talk to. And in looking at estate planning and understanding estate planning and understanding the need for estate planning, it's really about preparedness. It's really about making sure that your wishes are met and that somebody else isn't going to make a decision for you, not only as to whom the assets that you have accumulated during your lifetime are going to go, but the way in which they're going to go to those people. Over the years, a lot of people have thought that estate planning is for the wealthy. But the truth of the matter is, regardless of what your wealth level is, I presume that most people would prefer to decide where and how their assets would go rather than letting somebody else decide that for them. So, while a lot of people look at estate planning and kind of equate it, if you will, to tax planning, that's only a very small portion of what we're talking about here. The lion's share of what estate planning is, it's about family planning. It's about protection of assets. It's about, determining the proper distribution pattern, making sure that, children get what they're supposed to get when they're supposed to get it, grandchildren are taken care of, and really to make sure that the assets go where you want them to go to and not to somebody else.
Right. I could totally agree with that. The part that you said that really I try to hammer home with a lot of clients, and even when I'm actually teaching, et cetera, is the part that you said, someone else making a decision for you. I don't think people understand exactly what that means. So can you explain to people what you mean by that?
Well, simply, I mean that there is a law that in every state, and every state is a little bit different. It's called the Law of Intestacy. So if you die without any plan in place, the government, through the laws that they've set up over the years, is going to determine who's going to become the beneficiary of your estate. Simply put, if you are married and have a child, and I won't say everybody, but a lot of people say that if I was married or I am married and if something happened to me, I want my assets to go to my spouse. If I die without a will, they don't go to my spouse. If I have children, my spouse will get a portion and my children will get a portion. That may not be the plan that you look to put in place. So within a will, within a trust, you can decide who gets the assets, not some law that's been on the books for forever.
Right. So if I'm single and I don't have children and I die, what happens if there is no will exactly?
So if you're single and you don't have a spouse, you don't have children, then there is a list of what are called distributees within the law under this intestacy provision, and it goes down who is going to get the assets. So it might be your parents, it might be your siblings, it might be nieces or nephews. There's just a general list as to who's going to get them, but you're not going to make that decision. The law will have made that decision.
So is there anything in that's, I thought there's something that's in writing or something to that magnitude in the legal law that if I die and I'm single, not married, no children, that the law, it goes up first, which would be mom and dad, and then it goes down to siblings.
Yes, that's correct. But up may not be the way you want it to go.
Right.
You may have either elderly parents who giving money to may impact long-term care costs and things like that. You may have parents that are wealthy, where giving them money is just creating further estate tax consequences that maybe they have already planned to try to avoid. You may have parents, there are people that don't actually like their parents and don't talk to their parents. That may not be the direction you want the assets to go. You may have siblings that need the money more than your parents do. So there's, again, regardless of what the law says, if you want to follow the distribution pattern that it sets forth in the law, you can do that, but at least let it be your choice.
Right. I totally agree with you. Why do you think, Neil, that people do not have a will?
Oh, there's a lot of answers to that one, Phil. I think
What are the top three things that
I would say number one is that there is this weird thought out there that the minute you start talking about your wills, that's the end of your life.
right?
And that somehow it is, you go from will to death. It's it's like a connected thing. And people will tell me all the time they don't, quote, like to talk about it. Just something that people don't like to talk about. That is a very difficult thing for us in our profession to really, or in any of our professions, any of the financial world, to really deal with, because there's no connection between creating a will and death. And like I said, I'd rather have the conversation about it and be able to make my choice rather than letting somebody else choose. Probably the second biggest reason is cost. People don't think it's necessary. People think that there are easier ways to do it, and they don't want to spend money to do it. And then probably the third reason is just ignorance. It's
Yeah.
really just a lack of knowledge as to what is really important in terms of planning, and a belief that somehow if you have a spouse or you have children, that the natural law is what should follow. Well, if I'm married, then if something happens to me, everything should go to my spouse. It doesn't work that way.
Right.
So I think it's fear, it's financial, it's ignorance. I think those would probably be the three. And ignorance is more of a concept of just not having been educated about the importance of these things, and maybe listening to parents and grandparents who 30, 40, 50 years ago just felt they could do everything without the need for legal documents.
Right. If we can get anything accomplished during this podcast, it would be really for those people out there that say to themselves, I'm not going to worry about that. I'll let my children worry about that. Right. Help those people understand why that's problematic.
Well, I think continuing the conversation, first of all, is to say that just because you have children doesn't necessarily you want them to be the beneficiaries, or you might not want them to be equal. You might have one child that's doing better financially than another, and you want to make sure that you're taking care of people who need to be taken care of. You might have a child who's going through a marital issue. You might have a child who unfortunately has some addiction issues. You might have a child who just got themselves involved in some trouble and has lawsuits and judgments against them. So just leaving things to children is sometimes very dangerous. Obviously, that's not even really addressing the fact that that's fine as long as your children are of majority. But if your children are minors, there are issues there. If any of your children should happen to predecease you, and who do you want their share to go to, and how old are your grandchildren, and what about in-laws? There's avoiding planning is not a good way to go. I think there's an expression. The expression is failing to plan is planning to fail.
Yeah.
And whether it is planning from a financial perspective, whether it's planning for tax planning in terms of income taxes and your filings every year, or ultimately doing estate planning, not doing it is probably the worst thing you could possibly do.
Okay, so we convince people that you should have a plan.
Yes.
So they come to meet with you. what is the most basic forms of estate planning that everybody should have at a minimum?
Well, everybody should have a document that makes a determination as to what happens to their assets at the time of their death. Now, there are different forms of that document. There can be the utilization of a last will and testament. There could be utilization of trusts. There are different types of trusts. Some trusts are revocable, meaning they can be changed at any point in time. Some trusts are irrevocable, meaning that they're more set in stone as to what the provisions are. They have different utilizations, but some document to make a determination as to what happens to your assets during, at the time of your passing. But as part of all of this, there are lifetime parts of planning that are important as well. So creations of a power of attorney to potentially give somebody the opportunity to oversee and help you with your assets or take control of your assets if you are unable to do so. Similarly, there are healthcare directives, healthcare proxies, and living wills, which will give somebody the right to make medical decisions for you, or at the very least, get medical information about you if you're incapable of doing so. There are a lot of people that believe, and we've got lots of clients, you have lots of clients that have been married for 20, 30, 40, 50 years. And even if you have been married for 50 years, if a husband becomes incapacitated, the wife or the spouse does not have any legal right to deal with the other spouse's assets.
Right.
Absent some power that's been granted to them by their spouse during lifetime. So whether it be through the use of a trust, whether it be through the use of a power of attorney, the basics are to make sure that your assets are transferred at the time of your death and to make sure that you're provided for the rest of your life.
Right. So the basics are a will, which is a document with your intentions. Number one. Two, durable power of attorney. Three, healthcare proxy. I agree. The most basic forms of estate planning.
Yes, and with the healthcare proxy is generally a living will.
Living
The
will.
healthcare
Right.
proxy is the directive as to who is going to make those decisions for you, and the living will is basically a statement of what your intentions would be.
Correct. The one thing when I used to teach estate planning, one thing I really help people to understand the importance of a durable power of attorney. That, for example, let's say husband and wife, God forbid the wife gets into a serious car accident in the hospital, and an advisor needs to call the spouse looking for the spouse who's in the hospital, but that person in the hospital is incapacitated, and then speaks to the spouse. But because the spouse has durable power of attorney, right, an advisor can take instructions on what to do with that particular account, whatever it is at that moment.
Yes.
That's super important, right? So this is what I want people to understand the importance.
It's incredibly important, Phil. To
Right.
be quite honest with you, we tell people regularly that as important as wills are, as important as healthcare documents are, for many people, the power of attorney is the most important document they could possibly have.
Yeah, I totally agree with that. Now, the most simplest form is what we just said: will, durable power of attorney, healthcare proxy, living will. Now, again, what I've found from my experience is that when it comes to trusts, people hear that word trust and it says in their head, they're like, oh my gosh, I must have to be worth multiple millions to utilize a trust. So I want to, and again, the most simplest form, let's start first with the benefits of a revocable trust.
So a revocable trust, just so everybody understands, is a document that ultimately takes the place of a will. Call it a will substitute. It is a trust agreement that ultimately its main use is to make a determination as to where your assets go at the time of your death. The main difference between having a last will and testament and having a revocable trust from a death time distribution perspective is the avoidance of probate.
Right.
Probate is the process by which a will is determined to be valid. So there is a court that gets involved to look at a will to make sure that all of the formalities of the execution of the will have been met. Any minors are properly represented. People that might have any objections have had an opportunity to object and have passed on the objection. And ultimately, the court will stamp effectively, not literally, but figuratively stamp the will as valid and appoint somebody to be the executor who is now in the role of administering the estate. And for a long time, and in many states and in many locations, probate for most people is not a major problem. I've got a wife and 2 children. If the 2 children are both of majority and everybody sort of gets along, the concept of probate is not one that is an overly burdensome concept. But when you get into situations of minor children, disinheriting somebody, people you can't find, old documents that may have been executed a long time ago, probate can be a little bit more difficult. Plus, one of the things that we learned, we all took different things out of the pandemic that we went through, and we try to use history as something to teach us so that we don't do it all over again, is there is now, at least historically, a time in which the court system was shut down. I don't think as a lawyer, since I went to law school, I ever would have believed that the court systems would have been shut down for anything.
Right.
But back in March of 2020, we shut down the whole world, and part of that was the court system. And as a result of that, if somebody did pass and assets were needed to be obtained, you can't do anything without probate. And so when a court system is shut down, you can't probate. And even when the court system reopens, if it's bogged down, if we're down with staff, all of those things, it just takes time, a little bit more time. So we look to the revocable trust in terms of avoiding probate in order to make the ability for us to transition the assets between spouses or to the next generation a little bit easier and a little bit quicker.
Right. So the revocable trust, it could help and save, because what happens if you don't have a revocable trust, most likely you'll hire an attorney to probate someone's estate, right? There's going to be a cost to that. Number one. Number two, by having a revocable trust, the beneficiaries can receive the assets rather quickly versus waiting till the probate process is over, which can take anywhere from 3 months to 6 months. God forbid you have another COVID situation.
Yeah,
maybe longer than
I don't want to scare people into thinking that probate is the worst thing in the world. First of all, so that you understand, so that everybody understands, the general administration of an estate is the same whether you have a revocable trust or whether you have a will. So whatever involvement you have with accountants, attorneys, financial advisors, most of it is the same. The main difference is that period of time where the court has to make the determination if the will is valid. In most circumstances, that is not a multiple month process.
Right.
In most circumstances, it could be 4 weeks, 6 weeks, 8 weeks. You're generally not talking about probate taking 6 months. Administration, liquidating the assets, gathering the assets, figuring out what's there, doing everything that needs to be done in terms of filing of tax returns and that may take a little bit longer. But those types of things need to be done whether you have a revocable trust or whether you have a will. It's just that initial part of the court. Now, there are other states, Phil, where the probate process is a much more hands-on process from the court than it is here in New York.
Right.
So, if I want to sell something that's in an estate in New York, the court doesn't get involved in that. In other states, it does. So depending on where you are, probate can be a little bit more complicated, a little bit more time consuming. But as a general proposition, yes, it does speed up the process. It does save some costs, but you don't go from 100 to 0.
Correct.
In terms of cost and time.
Right.
There are still administrative things that need to be done.
Right. So just talk about the benefits of a revocable trust if you have a property in New York and let's say you have a property in Florida. Why is it beneficial to have a revocable?
So that's one of the other reasons we use revocable trusts, and there are others aside from just the probate avoidance. This is sort of an extension of the probate avoidance. So if I reside in New York and I own property, we'll use North Carolina. I'll stay out of Florida for today.
Okay.
They're having enough issues down there. We'll use North Carolina. I own property in North Carolina. When I go to the New York Surrogates Court, that's the court that oversees the probate of an estate. The New York State Surrogates Court does not have jurisdiction over real property in any other state around the country. So if I own property in North Carolina, a New York surrogate, New York probate court cannot determine that I have authority to do anything over the North Carolina property. That would have to be done by a North Carolina probate court, for example. So while I'm not concerned about having one probate, I'd kind of like to avoid having multiple. So by having the revocable living trust and having the property in the revocable living trust, I don't have to go to both New York surrogate court and North Carolina probate court. I'm okay with one. Two, I'd like to avoid.
I agree with that. Okay, so we covered pretty much revocable trust. Now, irrevocable trust, essentially, as long as I've been doing this, we would utilize those trusts to take part of someone's assets, move it into this trust. Now that's irrevocable. In other words, it can't be changed, but I want to talk to you about that. In New York, that could be different. But assuming, it's irrevocable, we would typically move money out of someone's estate to avoid possible federal estate taxes and New York state estate taxes. So again, in the most simplest form, how would you explain an irrevocable trust and how can it be helpful for certain individuals or families?
Well, so there are a number of different ways in which we use irrevocable trust. And the main benefit of an irrevocable trust is that a transfer to an irrevocable trust is a gift. You're giving something to somebody. So let's say I have two daughters. One of them is basically 20 years old. The other one is 19 years old. I want to give them something. I don't want it back. I don't want to undo it. I actually want to give them something, whether it be for estate tax purposes or just because I'm a really nice guy and I want to give them something. But they're 19 and 20 years old. If I give it to them, the likelihood is they're going to do something dumb with it.
Right.
And I'd like to avoid that. So in that circumstance, using an irrevocable trust, yes, helps me with planning and all of those things, but also allows somebody else to oversee those assets, to provide for my daughters, allow them to utilize the assets if they need them, but protect them and make sure that nobody else that I don't want gets access to those assets.
Which I love, Neil. I don't mean to interject real quick.
Yeah, no, please.
So like what's so important to me, and I tell our clients all the time, and my mom and dad and everybody else, is, you and all of us clients have worked so hard to build the wealth that they have. And unfortunately, today we live in a very litigious society. Divorce rates are high. So exactly the way you just said it, the other goal of these trusts or purpose of these trusts can be to be utilized to keep the money in the bloodline.
Yes.
So if you could just maybe elaborate a little bit on that, it's kind of where you were getting at, or pretty much you said. But
yeah, so I think we live in a different world than a lot of people think. A lot of people think of trusts and they think of it the way it's portrayed on TV or it's portrayed in the movies or historically. Some of our older friends and clients will know, Bing Crosby. Bing Crosby many, many, many years ago established trust for his kids, but Bing Crosby wanted to control everything that his kids did and made sure that they didn't get any money until they were well beyond their maturity age. That's not the way trust planning is these days. The way we do trust planning now is by having somebody to oversee the money. We're not looking to, quote unquote, take it away from the beneficiary. We want them to benefit from it. We want them to have access to it. We want them to be able to use it to buy a house or buy a car or do whatever it is that they need to or want to do. But we want to make sure that if there is a marital issue, if there is a gambling, drugs, alcohol, all of those types of things, if somebody's driving down the road and crashes into somebody, any of those types of problems that could occur, we want to make sure that those people don't have access to our assets. Right. We're good with our kids having them or grandchildren or whatever. We don't want other people to get their hands on them. So we use trusts as an asset protection, liability protection, whatever the word is or the words are that people like to use. At the end of the day, it's a way to make sure that our assets go to our kids and nobody else.
So the trust conversation we're having here, revocable, irrevocable trust, they are useful vehicles, and you don't have to be a multimillionaire, but it all comes down to when you sit down with them, when I sit down with them, and we question and ask clients what's important to them about their life as they think about things going forward. If they suddenly die tomorrow, or spouse died, they both died, who's going to inherit this money? Are you comfortable with that? What are your goals with the inheritance legacy? And so through questioning is where you and I, you mainly, are going to design a plan for that particular client and go back to the client and say, hey, I think this makes sense to you. Maybe it's basic estate planning, right? Or you may say basic estate planning plus a revocable trust, or basic estate planning plus revocable trust and plus a revocable trust. And other types of trusts that are out there is typically the process and the way that works, correct?
Yes, so there's lots of people that run around and sort of say that everybody needs A, B, and C. Here in our firm, we don't believe that. Not everybody wears the same clothing, not everybody drives the same car, not everybody needs the same estate plan, but all of these different pieces come together to make a comprehensive plan. Somebody that walks into my office, it doesn't matter whether you have $5 or $5 million or $50 million. There are different aspects of all of these things that you may or may not need for different reasons. And that's what we do. We sit down with people like you. We understand what they have, who they're trying to benefit, and what issues or things they're looking to or concerning them. And we put all of that together to create a plan, to give them an idea, different ways to do things, give them reasons why in their circumstance, revocable trust works better than will, why in their circumstance, maybe they want to do an irrevocable trust, and they can get from really simple to really wildly complex. But it all depends upon what they're looking to accomplish.
Yeah. Great. Love it. To conclude the conversation as it relates to taxes, right? So federal exemptions, 12 million plus, New York state estate taxes, 6 million plus. For those who live in Florida, as an example, there's no state estate tax.
Correct.
So my question is, for clients that come to you and say, hey, Neil, we're planning right now for the $12 million exemption per person, but in 2026, it's going to sunset to somewhere around 6 million plus. How the heck do you plan for that? If things are going to sunset, why should we plan for that now?
Well, one of the good pieces of information we've received over the last couple of years is an understanding from the federal government that we get to plan based upon the exemption that exists at the time we're doing planning. So if we do have wealthier individuals, and there is an opportunity for us to take advantage of the $12 million exemption while it exists, if we do it properly now, even when that sunsets and reduces to 6 or 7 or wherever it's going to go, if at the time we did something and did planning, it was 12 million, we're kind of locked in at that number. So if you've got, if you're a wealthy individual who has not as of yet taken advantage of the availability of these higher exemptions, has not taken advantage of the estate planning techniques that are out there, has not taken advantage of the ability to gift assets and move things around, you are late to the party, but the door's still open.
Yes.
Okay, we haven't gotten to the point yet where they tell you, sorry, the room is full, we can't come in anymore. We still, and listen, I never know what's going to happen at any point in time. It could change tomorrow.
Right.
But virtually every proposal that we've seen in the last few years has been prospective. So to the extent you have done something, it will be grandfathered, if that's the word people like to hear. So for years, I've been saying that there's no better time to plan than right now. It keeps getting a little bit better because the exemption keeps going up and up and up. But at least until they change everything, there really is no better time to plan than right now. So, and for people that live here in New York, there is some major benefit to doing planning now, to utilizing that $12 million exemption, because if done properly, if you were to transfer assets now and live for at least a 3-year period of time, everything that you're moving out of your estate is getting out of your estate for New York State purposes as well. So even though there's only a $6 million exemption for New York State, you may actually be able to get a lot bigger bang for your buck. But again,
Right.
time doesn't get better. We're not getting longer here.
Right.
It's time to move now.
Yeah, that's an important message that a lot of people who fall into that range, it could really be helpful by planning for today. And then finally, when you set, if you do propose a trust, you and I are sitting together, you say, hey, Phil, you need this trust, you need that trust. And you say to me, Phil, you got to name trustees. What advice do you give somebody in naming the appropriate trustee or trustees?
So in all honesty, Phil, I had this conversation probably about an hour ago with a client who was here, who we were talking about various things. And at some point in time, we came around to the conversation of trustees, and the spouses said, well, that's going to be the most difficult thing. What do you recommend? And my answer first and foremost is to think about the word trustee and to understand that the root of that word is the word trust. So first thing in your mind is whoever you are going to name, you have to have implicit trust in them that they are going to do the right thing and follow your directions. Number one. Number two, you have to be realistic in understanding your financial situation, and you have to be realistic in understanding the financial capabilities of the people that you are putting in place. Just because somebody is your child, and this is a very difficult thing to say to parents, because every parent believes that their child is capable of doing anything. Just because somebody is your child doesn't mean they're the right person to be your trustee, because they may not have the capability, the capacity to handle finances. Now, they don't necessarily have to be able to watch CNBC and pick stocks. They have to be able to surround themselves with the proper representatives, with the proper professionals, to be able to guide them and advise them and listen to the guidance and advice that they are getting. Some people just can't do that, okay? Some people have external influences, whether it be spouses or in-laws or relatives or friends or whatever, that are constantly chirping in their ears, and maybe that's not the right person.
Right.
So there are a lot of parts to all of this, and in the proper circumstance, or in a lot more circumstances now, it might be time for you to think of a professional trustee to get involved, whether it be professional in terms of a professional individual that you know who can handle those types of things, or a corporate entity who has guidelines and rules and oversight and all of those different things, who can provide the protection. And it might even be some combination. New York's a little bit behind the, kind of the rest of the world in terms of trust law, but there are a lot of states around the country where you can have multiple trustees and give one trustee one responsibility and another trustee another responsibility. And hopefully someday New York will find their way to allowing us to do that as well, because that is a fantastically beneficial thing for individuals to be able to do, to have somebody who's in charge of investments and overseeing money, and somebody else who's a little more family oriented,
Right.
in charge of distributions.
Right.
So I guess in closing of all of this, what I would say is you've got to be careful as to who you pick.
Right.
You've got to really give it some thought. It's
Really
not
do.
just, hey, Johnny's my oldest son, therefore he's going to be the trustee, because Johnny may be the last person in the world who should be your trustee.
Yeah, I've had a
I
client.
apologize to anybody named Johnny out there.
I've had a client change their trustees 3 times. Yeah, it happens. You're right. It's really important to pay attention and take your time to make sure you pick the right person.
Which, by the way, let me just say one more thing.
Sure.
One of the things that we talk about to all of our clients, look, it's great that you're here. It's great that you're doing this. Wills, powers of attorney, living wills, healthcare proxies, trusts. They are not something to do and then put in the drawer and never think about them again. It's hard enough to get people in the first time. I
Right.
understand that.
Right.
But I try to make people very aware of the fact that this is a living document. These are living documents. Circumstances change. Children things happen to them, grandchildren are born, the people that you name as trustee, they're no longer in your life, they die, they have their own issues, whatever it is. You can't just take this, put it in the drawer, and hope 30 years from now it's okay. I've got clients who walk in, the last time they did their will, they had to name guardian for their minor children who are now in their 50s. I guess the good news is that they're still alive, so the fact that they haven't looked at it for the last 40 years isn't really a problem.
Right.
That is not what we're talking about. This is not a one-shot thing. This is something that, like sitting down with you and talking investment strategy, sitting down with accountants and talking about tax returns. This is not something that you should be doing just once. It
It's
should be
gotta be
regular.
ongoing basis. That's great. That's a great way to conclude our conversation. So Neil, you've been really terrific, really giving a full gamut of estate planning. Thank you so much for your expertise. You do a great job for my clients. I appreciate all the work that you do, and I wish you a great day.
Thank you very much, Phil. Thanks for having me. I appreciate it.
All right. Take care now. Thank you.
Take care.